Good morning. This is the Colorado Energy and Carbon Management Commission. It is the 23rd. It's 9 a.m. This is our weekly business agenda. Let's take a roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross, Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Ray, Commissioner Robbins.
Here.
Mr. Chair, you have four commissioners present. Welcome back.
Thank you very much. Good to be back, I sort of say. Um, had a good time off, refreshed and ready to roll here. We start with commissioner comments. Does any commissioner have comments? Seeing none, we move to consent. Does anyone have questions on consent agenda? Seeing none, I would move to approve consent. Do we have a second?
Second.
Motion and a second. Any further discussion? All in favor signify by saying aye.
Aye.
Any opposed? That motion carries. All right. The next matter on our agenda is a commission data integrity update from Director Murphy. She's in another meeting and will be available at about 9:15. So I would suggest let's take a short break and return at around 9:15, in which case we will take up the data integrity update. So for everybody listening, just bear with. We're going to be back in about 14 minutes. All right, welcome back, commissioners. This is the Energy and Carbon Management Commission meeting on July 23rd. We are reconvening and hopeful that Director Murphy is with us and has finished up her meeting. Look at that. Magic. All right. Earlier we had Mr. Kupsel and Mr. Leonard and Mr. Lindley. If they want to visualize as well, or if you just want to take it away, Director Murphy, the floor is yours.
Thank you, Chair, and thank you everybody for your forbearance with a little scheduling hiccup for me. We wanted to take a little bit of time this morning to come back and present to the Commission and the public about the status of an ongoing investigation. And so today you'll be hearing from ECMC staff, who will be providing an update about the alleged submission of falsified data by contractors on behalf of operators to ECMC. At a previous hearing, we requested and you directed staff to return with quarterly updates. This is our fifth update. All of our previous updates are posted online on a web page devoted to this topic so that folks who have questions about what has happened and what we know is that information is readily available and accessible to the public. And that link is on your screen or will be shortly. And so today's hearing, we will also be making available as quickly as we can, because I know that there are many folks who have a keen interest in this topic. I do want to share a couple of high-level comments before I turn it over to Mr. Kupsel, Mr. Lindley, and Mr. Leonard for more detail. They will then return it to me to close us out, and then we will be available for questions from the commissioners. So I want to reiterate what I've said numerous times, which is this remains a disheartening and heavy subject. And as you will hear, our investigation has revealed further issues than were initially reported to us. And we will be trying to discuss that in some detail and also talk about what our path forward looks like. In many cases, right, the identification of the issue is quote unquote easy. For example, right, with the well control incident, there was clearly a well that did not have control. This situation is a little bit more complex because the information that was submitted to us needs to be evaluated and refined to discern what is accurate and what was manipulated. That has taken time and a commitment by our organization and the other organizations looking at this to understand what data was manipulated. That said, we remain committed to the protection of public health, safety, welfare, and the environment and wildlife resources. I want to commend our environmental data team for their laborious investigation to determine the breadth and also understand a path forward, which is the focus of today's conversation. I cannot overstate my appreciation for their hard work. They've approached the situation with integrity and a level-headedness necessary to help, again, craft that path forward. We've gone through an extremely tedious investigation to look through the volumes of data that have been submitted and understand what has happened, what hasn't happened, and where we need to go. So I want to thank this team's hard work, and we can begin to move forward as is kind of the tenor of today's update. To do that, we first need to oversee the remediation of impacted locations. We've talked about that a lot, right? This doesn't present new risk, but we do need to understand what is on site and how to make sure it is cleaned up in accordance with our expectations. Second, we also need to correct the data in our system, and that is an intensive undertaking, which I think you'll hear about quite a bit today. And third, we have to take enforcement action, and that is another topic of today's conversation. So today's presentation actually has 4 components, even though I just outlined 3. First, Mr. Kepsel will describe his investigation and methods into the investigation and what's been identified. Then Mr. Kepsel will describe the remediation measures that we are requiring of operators. I think this is what is interesting, right? There's the on-location remediation, the cleanup of the site. We all have talked about that in great detail. We continue to talk about that. And then there's a second component of cleanup that we're calling, for lack of a better term, administrative remediation or data remediation, or making sure that we understand what data was falsified and how it's been corrected, and that that is preserved in a way that people can continue to monitor and understand to build confidence in an understanding of what data is in our system, given the manipulation that has occurred. So those are Mr. Kepsel's 2 topics. Next, Mr. Lindley will be describing the enforcement action we have taken at ECMC. And here's our spoiler alert for the day. We've issued 7 NOAVs to the registered operators based on the data that we have received and reviewed to date and identified as manipulated. ECMC rules continue to reflect the most protective regulations in the country, and we have a robust enforcement program to ensure operator compliance with these rules. Our staff routinely monitors operator compliance with rules and holds operators accountable. When an operator is alleged to be non-compliant with our regulations, staff has authority to investigate, issue NOAVs, move that through the enforcement process, and bring it to you, the commission, to impose penalties and issue orders. So we are at stage gate 1 of that, and I believe Mr. Lindley will talk in greater detail about it. Finally, Mr. Leonard will bring us home, right? He will describe the measures we have put in place to reduce the likelihood of our agency receiving manipulated data in the future, and he will also describe the ongoing investigation we are undertaking to continue to make sure that we understand the complete scope of what data has or has not been manipulated across all of our remediation projects at ECMC. So this is a lot. It continues to be difficult, but we continue to make it a priority for us to painstakingly go through all of the data, understand what it says, and then chart a path forward. I've said it before, I'll reiterate it now. This is aberrant. Like, he still can't say that word very well. Sorry. This is a really disappointing situation, and maintaining the integrity of the data upon which ECMC or any regulatory body bases its decisions remains essential. Our permitting, compliance, and enforcement procedures, including the submission of reports, data, and samples by operators, are grounded in an expectation that all parties abide by the law and follow basic, professional, and ethical codes of conduct. We hope to conclude the situation, even though it has affected a number of sites, and we also continue to want to explain that this is a relatively isolated number of nefarious actors who have betrayed our trust and their profession. And with that heavy topic, I will turn it over to Mr. Kepsel to paint a much brighter picture about what we know and where we're going as we move forward.
Mr. Kepsel.
Thank you for the introduction, Director Murphy. Good morning. I'm Arthur Kepsel, the ECMC Environmental Data Group Supervisor. Today, I am going to provide an update to the falsified data investigation being conducted by ECMC staff. Today, there are several important updates to share with you regarding the ECMC data falsification investigation. Specifically, I'm going to talk about the investigation methodology, the investigation findings, and the remediation requirements for the next steps. Further, you'll hear about the NOAVs and our agency's steps moving forward, and we'll also have time for questions. To start, we're going to go through some of the history, methodology, and findings for the investigation. To start with a little background, and to start out with, to describe our investigation, I'd first like to describe the environmental data unit team that conducted the investigation. The environmental data unit that conducted the investigation was formed to primarily to review and maintain the analytical data received through the Form 43, including baseline water quality data, produced water, and production fluid and gas. The unit also provides support to the Colorado Produced Water Consortium, providing data extraction, compilation, and analysis. The Environmental Data Unit has experience with investigations that require assembling and interpreting large amounts of data and assists other ECMC units with investigations that require large amounts of data extracted from ECMC databases. The Environmental Data Unit is made up of 3 environmental protection specialists and a data manager. All staff members have experience with extracting and compiling data from various databases for use in tables, figures, maps, or for additional analysis. The EPS staff has experience with remediations, geochemistry, water resource management, as well as SQL data management and other data analysis tools. Throughout the presentation today, you'll hear a lot about Table 915-1. And Rule 915 and Table 915-1 set standards of contaminants of concern in soil and groundwater, as well as soil suitability for reclamation. Rule 915 also lays out acceptable analytical methods and sampling procedures for operators to follow. And oil and gas locations can include well pads, tanks, batteries, and pipelines. Form 27s will be referenced many times throughout the presentation as well. Operators are required to complete a Form 27 site investigation and remediation work plan for several reasons, including the closure of oil and gas facilities and the cleanup of spills. A standard Form 27 may include several hundred data points. Much of the information is attached to the forms as PDFs, including lab reports, data tables, figures, maps. The ECMC environmental staff processed over 16,000 Form 27s in 2024 alone. Form 27 data is posted publicly to the ECMC website on review and approval, or in some cases denial, by staff. ECMC environmental protection specialists review Form 27s for completeness, adherence to the ECMC 900 series rules, and data integrity. Provided analytical data is reviewed against the ECMC Table 915-1 cleanup standards throughout the life of the project. In order for project closure, Table 915-1 MCLs must be met. To remind the commissioners how the situation came to light, staff has provided the following timeline. In July of 2024, State Attorney's General Office was contacted by Eagle Environmental Legal Counsel about instances of data falsification related to Chevron. In August of 2024, the ECMC received notification directly from Oxy about data integrity issues. In September 2024, ECMC began to receive limited data tables from the Eagle consultants via their counsel. At this time, the ECMC also began evaluating data tables provided by the operators. In October of 2024, the ECMC received notification directly from Chevron and began discussions on their investigation progress. And throughout this time, the ECMC's awareness, the scope and scale of the issue, as well as access to actionable information, started to grow. And it still continues to grow at this time. In November of 2024, ECMC announced that 2 environmental consultants, Eagle Environmental Consulting and Tasman Geoscientists, hired by oil and gas operators, submitted falsified laboratory data reports to the ECMC between 2021 and 2024. All falsified data was submitted through the Form 27 Site Investigation and Remediation Work Plan. In October of 2024, the ECMC formally commenced the data falsification investigation. ECMC interim director issued memos to staff, and in November of 2024, the ECMC publicly announced the data integrity concern. December 2024, ECMC received notification from Civitas of similar data integrity issues. Also in December of 2024, ECMC publicly posted data sets and known locations. Throughout the time period from October of 2024 through December of 2024, ECMC received data updates from operators, worked on evaluating the data that we had access to, managed the ongoing workload of these affected and thousands of other active remediation projects, and was also at this time was soliciting contractors to support a larger investigation going beyond the scope of the operator reported data falsification. You'll hear more about that later. Coming through the lab reports, literally comparing each line of text from both the falsified lab reports and unaltered lab reports side by side took operators time, and then compiling and then analyzing the data we received took a significant commitment of ECMC staff resources in addition to the day-to-day workload. Staff has reviewed spreadsheet data detailing falsified data identified through the operator internal investigations, as well as conducting our own review. To date, staff has reviewed over 1,000 PDF documents. Of those, staff reviewed 683 lab reports provided by operators. Of those, staff compared 520 original unlocked accessible lab reports to submitted lab reports from Chevron. Staff has reviewed a total of 3,275 individual instances of falsified data provided by the 3 operators involved. Of those, 2,800 instances of data falsification can be attributed to Chevron remediation projects. And I'd also like to take a minute to specifically call out the work that Selena Demi completed reviewing and cataloging all these instances of data falsification in the lab reports. During the review, Selena found additional instances of data falsification that were not immediately identified by the operators. And some of the summary of the data that we have received. So far, we have 284, from Chevron, we have 284 remediation projects with 520 lab reports that were affected. And they reported to us 1,681 individual data fields that had been manipulated. Civitas reported 47 remediation projects with 82 lab reports and 287 data fields that were manipulated. Oxy reported 74 remediation projects with 81 lab reports and 126 data fields reported. And staff identified approximately another 1,100 altered data fields that were originally not reported. To date, 404 remediation projects in Weld County and operated by Chevron as Noble Energy, Oxy as Kerr-McGee, and Civitas made up of subsidiary companies 8 North, Bonanza Creek Energy, Crestone Peak and Extraction Oil and Gas, and High Point. Of the 404 total locations found so far, 187 are active and 217 are closed. Closed for this instance means no further action was granted prior to the ECMC initiating the data falsification investigation. These sites were previously closed based on information provided to the ECMC on Form 27s. Active sites were under active remediation at the time of the data investigation began and are still open today. This slide combines the information I shared in the previous 2 slides and displays the number of open and closed remediation projects by municipality and the operators with projects within those municipalities. Director Murphy has been in regular contact with these municipalities, and our staff reached out earlier this week to provide advance notice about today's hearing and update. Also importantly, surface owners of data affected sites were notified by the ECMC in December. Some of the results of our investigation found that the range of information falsified is quite broad. I've tried bundling the types of information, of falsified information, into 4 categories. First of those is analyte data. These include target analyte results, and the actual target analyte and laboratory result. For example, something such as sulfate with a result of 10 would be considered an analyte result. The test report limits, the testing reporting limits and detection limits are necessary for staff to determine the usability of the data. Staff generally will not be using data that has reporting limits or maximum detection limits greater than the table 915-1 standards to make decisions such as for a site closure or analyte reduction. The quality control category goes to the validity of the laboratory analysis. Things such as spikes, surrogates, and the percent recovered show that the lab data run was within acceptable accuracy standards. Dilutions are closely tied to the reporting limit and method detection limit. By diluting a sample may push the reporting limits or maximum detection limits out of the acceptable range for other analytes. Changes were also made to the formatting of the reports. So these were changes to the main body of the report. In particular, there were columns that have been added and removed from some reports. We also have an administrative category that includes things such as notes, laboratory issue dates, and in some instances, personnel such as the laboratory project manager and signatures were falsified or changed. Also, lab staff analysts' initials were changed. The slide shows the results of some of the affected categories, particularly this shows all categories together. And as you can see, the most heavily affected category is the analyte data, followed by the QC data, and then administrative and formatting. And within these graphs, you'll see that there's a blue and orange line. The blue represents instances of falsification reported by operators, and the orange is instances found by staff. And this one now just displays in the analyte category, and it shows the target is most heavily modified, followed by the reporting limits, minimum detection limits, and on occasionally notes within the analysis. This graph displays the count of falsified soil data by analyte. All fall in the analyte category. As you can see, many of the largest falsified data related to arsenic, pH, and barium. The next graph displays count of falsified water analytes. As you can see, most heavily reported, or most heavily falsified data in this reported so far is benzene, trimethylbenzene, 1,2,4-trimethylbenzene, naphthalene, and 1,3,5-trimethylbenzene. The following graph is a falsification count of the QC data category. Excuse me a second. This you can see the falsification, most heavily falsified data was related to the quality control, included the spikes, the reporting limits, percent recovered, and surrogates, as well as dilutions. In the administrative category, we see that notes and dates, signatures, and the analysts were changed. And last was the formatting category. And this shows that there were columns removed, columns added, project names changed. So now we're going to have a couple examples of some of the falsification that occurred. In the opening remarks from Director Murphy, she stated that this remains a disheartening and heavy subject. And the following examples are the embodiment of that statement. I was requested to come up with two different examples of data falsification. One that showed data falsification through time, meaning multiple instances of data falsification across the time for one site. And one showing the worst degree of magnitude, meaning the most spread between the original lab report data and the falsified data. As it turned out, the two examples ended up being from the same remediation project. The next series of slides show an extreme example of what data falsification looks like and what it means for both the environment and the remediation project. The slide that we're currently on demonstrates how the contractor manipulated benzene data over time at the same location from October of 2021 through September of 2023, so over a period of about 2 years. And it shows multiple instances where lab reports had the benzene results modified, lowering them to below the benzene MCL, which is 5 micrograms per liter. This graph shows in particular for monitoring well number 2022, showing the results of 3 separate monitoring events where the benzene concentrations, the original benzene concentrations, were above the MCL and are shown in orange. The falsified data was falsified to show that the benzene concentrations were below table 915-1 MCLs of 5. The MCL is shown on the graph in the dark black line. This graph is very similar to the first one I displayed. However, this is for MW3R, so this is another monitoring well where the same kind of falsifications took place. Again, the original unaltered data is shown in orange on the graph. The altered data is shown in light blue, and the benzene MCL is shown as a thick black line. In my last example, I will provide the worst degree of magnitude data falsification that we have currently found. This slide shows the original unaltered lab report data on the left and the falsified lab report data on the right. This is an example from monitoring 1W MW01R. And this displays, again on the left, the original benzene concentration, 1,010 micrograms per liter, where it has been reduced to 4.55 micrograms per liter on the falsified report. And just as a reminder, the benzene maximum contaminant limit is 5 micrograms per liter. And this altered data shows that 3 orders of magnitude over the MCL. And this slide is another view of the altered data that is shown in the way we have cataloged all of the data. And within this slide, you can see that the sample ID MW1R was falsified to be dropped below the MCL of 5. The unaltered data was 1,010. And also another sample was falsified, MW5R, and it shows up on this as the unaltered data was 192, falsified data was 1.05. And this particular slide also shows that the QC data was altered. The alterations for the QC data show alterations from being in the high hundreds to below the detection limit as well. So what does this mean for the specific project? What you see here is a site with a significant documented benzene groundwater over several years from 2018 to 2021. And these screenshots came out of the attachments to a Form 27 that was submitted to us for this site. And as you can see, this is a highlight of the data for sample point MW1R. An air sparge remediation system was installed and started on this site in October of 2021. And immediately after startup, the reported benzene concentrations were below ECMC cleanup standards and even below laboratory reporting detection limits. The remediation system was shut down in early 2023. So this sample for MW1R collected on 9/14/2023 and shown and circled in red on the screenshot is the falsified sample. This represents a confirmation sample that the remediation system worked. The ECMC requires 4 quarters of monitoring, demonstrating clean groundwater before a no further action status to a remediation project be granted. This 4 quarters of sampling accounts for seasonal variability and also monitors for post-remediation rebound. This would have been the 3rd quarter of the most post-remediation monitoring, and the actual data show rebound to a pre-remediation level of contamination. The site will have to be reevaluated, contaminants delineated, and new remediation efforts will have to be enacted by the operator. This project is situated on an agricultural property adjacent to an irrigation canal and in very close proximity to a surface water pond, which appears to be hydraulically connected to shallow groundwater. This is an egregious example, significant alterations over time affecting not just the regulatory outcome, but having actual consequences in the environment. Again, this was not new contamination, but it is contamination that was known about and not properly addressed. These actions affected regulatory decisions and resulted in a delay in cleaning up the known contamination. The only redeeming factor this project has, if it really has one, is that the site was never received closure from the ECMC. So now we've identified the issues, what are we going to do next? Broadly, at this stage of the investigation, there are 2 equally significant components to our role as a regulatory authority regarding remediation. Physical site remediation to ensure operator compliance, cleanup standards per rules and statute, and investigate and delineate the extent of impacts, remediate soil groundwater to table 915-1 standards, and also conduct administrative remediation through the ECMC administrative process, which will be to reopen sites as necessary, show falsified data in each of the remediation files, as well as obtain new, original, unaltered data in a secure lab data format, and reestablish compliance for each of the sites. The ECMC remains confident the falsified data created no new risks to public health because the scope of the impacted data is limited to site investigation and remediation work plans for sites that already have been disturbed by oil and gas development. In other words, the disturbances from the oil and gas operations at these sites is unchanged. The falsified data affects the degree of remediation work needed to remediate those disturbances. Nonetheless, remediation is certainly required. Some sites closed based on the falsified data. These sites would not have been closed had original unaltered data been timely and correctly submitted to the ECMC. Additional remediation would have been required at that time. Our approach has been and continues to follow the ECMC mission. And I'm just going to reiterate the last part of our mission, and that is to protect public health, safety, welfare, and environment, and wildlife resources. I'm now going to turn the presentation over to Trent Lindley with the enforcement group to discuss the notice of alleged violations that have been issued in this matter. Thank you.
Good morning. Thank you, Arthur. My name is Trent Lindley. I am the NOAV specialist in ECMC's enforcement unit. Let me please reiterate Julie's sentiment of gratitude to Arthur and his team for the work they have done and will continue to do in this effort. To recap, Arthur has described the investigation methodology, the findings of the investigation, and the ways in which we are requiring the operator to do remediation. The commencement of the enforcement actions is the next area we'd like to discuss. Director Murphy, next slide, please. Arthur, one more. Thank you. Director Murphy used the term notice of alleged violation, or NOAV. For you, the commission, and to anyone who will watch or listen to this update, pursuant to Rule 523, when the director has reasonable cause to believe that a violation of the act or of any commission rule, order, or permit has occurred, the director will require the operator to remedy the violation and may commence an enforcement action seeking penalties by issuing a notice of alleged violation. An NOAV is the first step in the enforcement process, and it includes allegations of violations based on evidence gathered by staff. Ultimately, you, the commission, adjudicate these allegations and issue a final order. ECM staff are experts at interpreting our rules and are the ones to determine when operations violate our rule, but our enforcement process is carefully guided by administrative processes to ensure that fairness and consistency are maintained as we navigate enforcement. NOAVs also include specific corrective actions, which are intended to abate the violation or prevent recurrence. Next slide, please. Next slide, please, Arthur. Thank you. 7 NOAVs were issued on July 22nd to the operators you see listed in this slide. The operators are listed under their parent companies in this slide because staff initially brought the data integrity information to you by those 3 parent companies. The NOAVs were issued to the registered operator record for each of the remediation projects. Next slide, please. The violations for each of the NOAVs include Rule 207 regarding accurate and complete reports, Rule 206 regarding training and supervision of employees to ensure familiarity and compliance with the Commission's rules. Excuse me. The corrective actions in each of the NOAVs require operators to submit a prioritized plan to comply with remediation direction provided by staff. Just to remind everyone watching, updated maps and data sets of locations impacted by data falsification can be found on ECMC's website and at the URL listed on this slide. Next slide, please. Thank you. Issuance of an NOAV is the commencement of an enforcement action and a formal legal process and the set administrative procedures for our agency. Each operator has 28 days upon receipt of the NOAV to file an answer. Once staff receives an answer, they will begin work toward filing their applications for hearing and going through the process of negotiating the settlement of each case. Also, because this matter will likely come before you for adjudication, no further information will be shared outside the publicly visible process of formal filings and commission hearings to achieve resolution. Each NOAV has corrective actions, which require the operator to submit a plan by August 19th. Operators will submit a Form 27 for each of the 404 locations to comply with direction provided by staff. ECMC's enforcement jurisdiction is established by the Colorado Oil and Gas Conservation Act. ECMC's investigation did not and does not include determining why the data falsification occurred, as that would fall outside the scope of ECMC's jurisdiction. ECMC referred this matter to criminal prosecutors for further review, assessment, and investigation. That concludes the overview of the initial enforcement actions that have been taken. Now our QA, QC, and safety manager, Mike Leonard, will take the screen next.
Thank you, Trent and Arthur, and good morning, commissioners. Again, Mike Leonard, QA/QC manager here at ECMC. I'd like to thank you, commissioners, for your attentiveness and patience in going through some very complex and sobering details. As we hope this last portion we know this last portion is just as important as the rest. So the question becomes, how do we reduce the likelihood of this situation happening again? Maintaining the integrity of the data upon which ECMC or really any regulatory body bases its decisions is essential. And reiterating what Director Murphy said earlier, are permitting compliance and enforcement procedures, and that includes the submission of reports, data, and samples by operators, are really grounded in an expectation that all parties abide by the law and follow a basic professional ethical codes of conduct. Although this is a disappointing situation, certainly expected to be an outlier, and we've taken some QA measures to reduce the likelihood of it happening again. Next slide, please. So the QA/QC unit was formed and developed to ensure continuous improvement, improving integrity of processes, auditing information, and identifying defects, and then working to remedy those defects. Our team's been charged with identifying other documents in the ECMC database that may have been manipulated. Frankly, that is the elephant in the room. Although we did not initially identify the issue, we will work to remedy the situation through an audit of ECMC documents and work towards measures to prevent future occurrences. Next slide, please. As an added safeguard, ECMC staff began examining the metadata for indicators of anomalies early on. We required lab reports to be standalone documents separate from the PDF reports. And in April, we increased security by requiring digitally certified signatures and password security on documents. We extended this security to Form 27s that were in process, and that would be forms that had not been approved yet, still in the system, whereby we requested resubmission of lab data for forms. Next slide. So ECMC has received tens of thousands of analytical reports, as mentioned earlier by Arthur, associated with thousands of remediation projects over the years. Based on these recent data falsification issues, ECM feels obligated to ensure that those lab reports for which operators have not identified as being manipulated do, in fact, have integrity. This type of analysis is the exact reason why the QA/QC unit was created. It creates an enormous challenge that we couldn't have anticipated so soon. We are creating an audit of the lab reports and codes to determine if what has been reported to us is the extent of the issue, or if we find a reason to believe that there's. Arthur earlier on described the process by which he was able to compare two PDFs. When we have both the original from the lab and the manipulated version from the consultant. It's much harder to do when you only have the one PDF and you don't know if it's been altered or not. The process of finding a way to review data submitted to ECMC has taken what seems to be a long time. But finding programs or software to detect anomalies in PDF submissions is not an off-the-shelf purchase. And keep in mind, we're talking about auditing thousands of forms. So manual review really is not an option. It took us several months just to find a firm that was willing to develop this process for us. Late in April of 2025, we were able to contract with a forensic investigation firm that was willing to undertake this task. In conjunction with that firm, we worked through May and June to determine if what we were asking was even possible. Those results from early testing were very encouraging. The firm was able to take in a blind test to determine if PDFs had been changed. Keep in mind, though, this test was very broad and they were able to show anomalies in the documents. We're working in the second phase of the project, whereby they're looking at specific areas of laboratory analysis documents to determine if changes have been made. We hope to work through that phase by the end of July or mid-August at the latest. Once that process has been refined, we will provide them with 200 randomly chosen laboratory documents, which they will again analyze and redline for changes. Once those results come back, we can then evaluate our system for further document testing. And with that, I'll turn it back over to Director Murphy. Thank you.
Thank you, Mr. Leonard, Mr. Kupsel, and Mr. Lindley for the summary. And I hope if I can quickly recap what we've been talking about this morning. I first want to acknowledge that I'm hardly a scientist, and I think that this level of detail in the presentation that we brought forward demonstrates the detailed and meticulous review that has required weeks and months by our team of environmental professionals. And while it's hard to encapsulate for those like me who may not have the same depth of experience in analytes and standards and, quite frankly, the deep science, I wanted to try to kind of bring us back out to the high level, which is the things that our organization is focused on. And I'm going to walk through 5 of them. 1, we are continuing to encourage and prioritize cleanup of remediation projects affected by the data falsification. The majority of the sites impacted were ongoing cleanup projects, meaning that the impacts were in place and were being managed. And that's, on balance, means that as we've discovered what else needs to be cleaned up, it changes the course or the trajectory of the cleanup, but doesn't change the fundamental truth that the cleanup needs to happen. So 1, our focus continues to be on getting things cleaned up. 2, when we compared original lab reports to the lab reports with manipulated data, we did identify some additional fields of data falsification than was initially reported to us. We did this to ensure that we have a complete picture of scope and the issue, to again ensure that the cleanup occurs in accordance with it. We presented you today with a very egregious example, but I want to reiterate that most other examples of falsified data involve inorganics and soil suitability standards or parameters, soil suitability parameters. And what that means for the rest of us is that these are constituents that exist in the soil anyway. And yet we have cleanup standards to them to ensure more effective plant regrowth and soil health. And so again, today's example was pretty egregious, but it really was to illustrate that there are some significant concerns, but it's not the example of most. 3, we are focused on correcting the data in a manner that is transparent, which requires methodically reviewing and updating the information in a consistent manner. This is a step-by-step process. It does take time. We are committed to doing it. 4, we initiated enforcement action today for operators' failure to oversee their contractors and failure to ensure that accurate data was submitted. And 5, our investigation is ongoing. And with the detail provided that you've heard today, I hope you can appreciate what a time-intensive process this has been and will continue to be. And more importantly, that it continues to be well worth our agency's expenditure of time and resources to ensure the accuracy of data in our system and cleanup of impacts. With that, I wanted to kind of try to recap it. I don't know if I did that very well, if I helped anybody. We will be available for questions. Given that we have also initiated a formal enforcement action, I would like to pose to the commission that we come back to you as with timely updates based on the course of that investigation that Mr. Leonard talked about, and recognizing that also the enforcement matters will be proceeding versus moving forward with kind of this quarterly cadence. I want to come to you when we have information versus when a time period runs out. So that's my ask to you, commissioners. I want to commend our teams, especially our environmental data team, for the laborious investigation. I want to commend Mr. Leonard for working through trying to find somebody who can look more broadly across all of our data. And I cannot overstate my appreciation for their hard work and their devotion. And Mr. Lenley and the enforcement team, your work is just beginning on this, and we will continue to work through it. This has been a lot. And again, we are in the midst of an investigation, so bear with us if if our responses guide us back to that piece. And with that, I'm happy to close staff's presentation and take questions from you, commissioners.
Thank you. Thank you. Thank you very much, Director Murphy, and to the team. Appreciate the report back out on this. I agree that now that this has moved into an enforcement proceeding, and I'm just going to remind commissioners that enforcement proceedings come to us for ultimate adjudication. So we don't want to dive too deep into details of something that's going to come to us with regard to an enforcement. With that said, just a general question or two that is not relevant to enforcement, but just sort of as to process. The data that was, so first off, I just want to make sure that we all understand that the operators that use these third parties for the data collection, they self-reported the falsifications. Is that accurate, Director Murphy?
The operators and/or their consultants came forward to us last summer to identify the issue, and we've just continued to look into that scope to understand that we understand what happened, the scope of what happened, and now we want to look more broadly at just to confirm in other situations, should other operators have relied on these consultants, whether there's anything we need to be aware of and move forward in investigating.
Okay. And then secondly, and this may be a dumb question, I'm not a scientist either, but the falsified data was relevant to ground situations, like elements that were in the ground. Is that as opposed to, and I'm asking this for others, elements in the air?
Right. That's correct, Chair. The falsified data came in from labs who had conducted soil testing at its most basic, right? And the context for this situation is EMP waste or waste from oil and gas exploration and production impacted a location. To get to cleanup, we need to know what's there. And so what the soil or the ground is tested in response to identifying that spill. And then that sets the course for the cleanup, which is the Form 27 process in all. So, right, we're not talking about air impacts in this context at all.
Okay. And I just think that's important. We talked about benzene, right? And we've heard lots of studies, et cetera, that that's a element that can have health impacts. But that's when it's related to exposing out of a flare or event or oil and gas operations as an emission. And that's not what we're talking about.
Correct. This is not a situation in which we've had air emissions issues with data falsification. When we encounter benzene or the types of constituents associated with EMP waste, we want to get them all cleaned up, right? And that is why we continue to maintain control of an oil and gas location until they are cleaned up. And that's why, again, we've been focused on trying to understand scale and scope. And what I'm indirectly getting to is that for locations that were closed and had constituents that have been manipulated, they will require cleanup to the appropriate standard based on what we now know is on site. Understanding exposure to human pathways is something that we're continuing to monitor and gets to why we are prioritizing work by operators and sites that have been closed to make sure that those are remediated most quickly to, again, reduce, to quickly get those sites cleaned up and returned to the surface owner.
And then in terms of each of these sites, right? and let me just see if I've got this right, but every oil and gas site does its production and then it's needs to be remediated to make sure that the ground soil levels meet the 915 tables. And during that process of going from non-remediated to remediated to meet our things, are these oil and gas sites open to the public?
No. And I think the only thing that I want to clarify in that statement is not every oil and gas location has a spill that needs remediation, right?
Okay.
Some sites go from production to reclamation to and are returned to service. So, and again, what these sites are, what we're really focused on in this instance are those places where we've had exploration production waste impact, i.e. a spill to ground. And then when that occurs, our Form 19, Form 27 cleanup processes kick in. And we are focused on, making sure that that cleanup process occurs as it's expected to under our rules.
Okay. Now, I appreciate that additional clarification. I think it's helpful for the public to understand what happened, what didn't happen, what we're doing to try to address those situations. I don't know that I have further questions. I open it up to my fellow commissioners. Commissioner Oath?
Thank you. And thank you, Director Murphy and team, for the update and for taking this very seriously. And appreciating that most of the sites are continuing to undergo remediation and that it's a sort of sounds like smaller subset that have been closed. But I do have a question about those that have been closed. I'm wondering if we know whether there has been any surface use approved or occurring on those sites, and if not, if we can ensure that the operators are looking into those sites and prioritizing that to ensure that no surface use is occurring that would create a new risk.
Thank you, Commissioner. I think it's a great point. And, from December, when we first really started focusing on discussing with municipalities and local governments and surface owners impacts, that has been the focus, right? Those sites that were closed are our top priority to get reclaimed. And, I want to continue to reiterate to our staff, to operators, that they are the top priority for revisiting and getting cleaned up.
Commissioner Messner?
Thank you, and thank you for the information on the topic, and appreciate the level of detail that was provided. For me, that's super helpful. I did have a question, I think, from Mr. Leonard associated with the kind of ongoing quality assurance compliance piece and the audit that you had spoken about. Those measures that you were indicating were being taken and will continue to be taken associated with, ensuring that that other data may not be falsified. That's broader than the two contractors that are associated with this particular incident, correct? Where that audit is looking at kind of data holistically, that has been provided to ECMC over the years. Is that correct?
Yes, thank you, Commissioner. And I broke up a little bit, but I think you're asking if we're looking at across the whole data field, and the answer to that is yes. In that, and I'll just let you know, in that 200 that we're moving into the next step with, what we have done is we've taken all of the analytical results supplied and approved by ECMC over the last 5 years. And we're breaking those down into 4 buckets because, as you can imagine, about 3 or 4 of the operators are the vast majority of them. So we don't want to just do 200 and just have 200 of theirs. So we're putting it into 4 buckets of 50 each. So we'll have some that have thousands of data. We'll have some that have hundreds of data and some that have tens of data. And we'll break it down then and see what it not only refines the forensic firm's point, if you will, on finding this stuff, it also gives us a better idea of how deep we need to dive.
Yeah, thanks for that additional information and really appreciate those additional steps that are being taken. I think that's a really important step in this situation and appreciate that that work is ongoing. So thanks for the information.
Further questions from commissioners? Director Murphy, any further wrap up given those questions?
I don't think so, Chair. I think we really appreciate the time and attention on this and know that we are continuing to really dig in and work diligently through the data and through the issues to get resolution on these different issues.
Great. Okay. And for, I think with that, we'll just wrap it up. We really appreciate the update. We change our course of action. We don't need quarterly updates. We just need updates relevant to the enforcement matters as is normal for an enforcement proceeding. And with that, let's take about a 10-minute break and return at 10:30 for our next business agenda matter. All right, welcome back, commissioners. The Energy and Carbon Management Commission business agenda will continue. We take up docket 241100286, an oil and gas development plan. The applicant is Verdad Resources LLC, and I see Mr. Obrecht is with us.
Yes, Chair.
Go ahead and introduce yourself for the record.
Alex Obrecht with Baker Hostetler. I'm outside counsel for Verdad Resources for the Jayhawk OGDP. We're going to present today on a 10-well OGDP that includes a 1,600 acre spacing unit in Township 10 North, Range 59 West. I'll be joined here today by the primary presenter, the regulatory manager for Verdad, Heather Mitchell. We will also have a few subject matter experts on the line and available to take questions. Those will be Mike Cugnetti, Director of EHS&R, and Jeff Berghorn, Vice President of Land, and also Allison Schreiber, Senior Regulatory Analyst. And with that, turn it over to Ms. Mitchell to take up the primary portions of the presentation.
Actually, before that, we're going to hear from Mr. Kavanaugh with Weld County. Go ahead.
Thank you. I appreciate your time today, and I wanted to say really thank you to the staff earlier for all their comments as relates to the update for the falsified integrity data update. So I know that's a lot of work, and at Weld County we appreciate it. So just wanted to say that really quickly.
I appreciate that, Mr. Kavanaugh.
No, it's important for us to learn that information. So thank you. Well, first of all, thank you again, commissioners, for your time and for the opportunity to speak for you for a few minutes regarding the Weld County local process for Verdad's oil and gas development plan. On May 22nd, 2024, Weld County held a pre-application meeting for the Jayhawk Fed 2833 location before you today. Attendees included Verdad staff, Weld County staff, ECMC, CPW, as well as CDPHE. The 1041 WOGLA application was received on November 11th, 2024. Weld County did not receive any public applications for intervention on this location. The 1041 WOGLA hearing for the Jayhawk Fed 2833 was held on January 30th, 2025. It was then approved by Weld County Hearings Officer. The final order was recorded with the Weld County Clerk and Recorder on February 11th, 2025. And published in the Greeley Tribune on February 15th, 2025, which creates a vested property right for this permit. 2A comments were submitted to the ECMC and were included in the director's recommendation. Weld County agrees with the director's recommendation and supports the approval for this permit. At this time, we appreciate your time and are open for any questions.
Thank you very much, Mr. Kavanaugh. As always, we appreciate your taking time to be with us and present Weld County's local government perspective on an oil and gas development plan application before the commission. Does anyone have questions? All right, seeing none, again, appreciate the time, appreciate the perspective. Take it under advisement as we take a look at this OGDP.
Thank you.
All right, Mr. Obrecht, if you want to elevate your witnesses, we'll have them sworn in.
Sure, I believe Heather is here as a presenter and ready.
Mr. Boudreau?
Thank you, Mr. Chair. I'll ask each of the witnesses to be visualized and to raise your right hand when I call your name, state your first and last name, and swear to tell the truth. We'll start with Heather Mitchell.
My name is Heather Mitchell, and I swear to tell the truth.
Thank you. Jeff Berghorn.
My name is Jeff Berghorn, and I swear to tell the truth.
And Mike Cognetti.
Mike Cognetti, I swear to tell the truth.
Thank you.
All right. Ms. Mitchell, I believe you were going to lead off.
I will share my screen and get started. One moment. All right. As mentioned, my name is Heather Mitchell. I'm the Regulatory Manager for Verdad Resources. And today I'll be talking through our Jayhawk Fed 2833 2726 Oil and Gas Development Plan. We have Mike Cognetti and Jeff Berghorn here to help answer any questions that you may have at the end of the presentation. Today, I will be running through our location overview and development plan, alternatives, best management practices, benefits of the development, as well as permitting and operational timelines. We wanted to start out by making a couple corrections to the director's recommendation. There were two statements that needed correcting. The first one was on page 3, where it states that Verdad plans to truck water. Verdad will have a produced pipeline for this location. And then on page 10, it stated that an oil and gas line were already in place. We do have a gas line in place for this location, but we don't have an oil line yet in place. It will be there by the time we produce. Just wanted to clear that up. This slide represents our proposed unit. Verdad will use one 17.63 acre location to develop a 1,600 acre spacing unit comprised of all of section 27, the north half of 26, and the east half of 28 and 33 in township 10 north, range 59 west. We'll drill 10 new horizontal wells and develop the Niobrara, Fort Hays, Codell, and Carlisle formations with one occupation. We do have 2 wells that will remain as part of this development on this pad, and they're shown here in blue. Let me just point them out to you. We have the blue are here. Those will remain as part of this development. And then we also show some gray wells here. Those are 4 wells on a unit pad, but that we will be plugging as part of this development. This next slide orients you to our proposed location within Weld County. We have a 2.5-mile radius around our proposed location, and our unit is outlined in red. The RBUs are represented by black diamonds, and there are no RBUs within 2.5 miles. High priority habitat is in yellow, and that is the mule deer winter concentration area, and our pad is partially within that high priority habitat. We'll be accessing the pad via Weld County Road 110.5 and Weld County Road 115. Our nearest municipality is Grover, and it's greater than 13 miles away. We do have an SUA, and we're not asking for any 604 setback variances. This slide zooms into our proposed Jayhawk Fed location, which is situated in the southeast of Section 28, Township 10 North, Range 59 West. It is an expansion of an existing pad, and of the planned 17.63 acres, approximately 7.5 acres are already existing. This location has no residential building units within a mile. It's outside of disproportionately impacted communities and away from schools. The site minimizes new land disturbance as we're able to expand an existing pad, use an existing gas line, and an existing access road. We weren't able to expand to the north outside of the high priority habitat, primarily because of the drainage to the north, as well as some arc sites that we weren't able to disturb. So we had to expand south into the high priority habitat. This particular location accesses the minerals in a way that will minimize drilling and completion timelines. Because of our proximity to high priority habitat and that we're partially within it, we did have to conduct an ALA per ECMC regulations. And this slide shows an overview of those alternatives. Each location is purple, and there's a 2,000-foot radius around them. The high priority habitat is this pink. Also of note, we have both solid green and hatched green, and those represent, the solid green represents unleased BLM minerals that we are not able to access, and leased BLM minerals that we are able to access. As we do with each one of our OGDPs, we look at the unit and see what we have available to use as options. Here we, in addition to our proposed location, we also had 2 other existing Verdad pads that we looked at for this development, and we eventually chose the Jayhawk Fed as we found it the least impactful. We also did look at some options inside and outside of high priority habitat. I'll be running through each one of the alternatives relatively quickly, but in the next few slides. Our first alternative was a reoccupation of a Verdad location, the Nelson Ranches 127-1059 location. And this was similar to our proposed location in that it's an existing pad with existing access and gas infrastructure. Also, no no RBUs. Schools are disproportionately impacted to communities, and that is the case with all of our alternatives. This pad would have developed our unit pretty optimally where it's placed in the unit. However, due to the rock outcrop and the terrain, we weren't able to expand this pad. It does fall also within high priority habitat. This pad is the one that will be decommissioning and plugging the wells as part of this development. The second alternative is in the northeast of the northwest of Section 28. It is outside of high priority habitat. This particular location would be brand new 10 new wells, new pad disturbance, new access road, and new pipelines. This one is more remote, so it's further away from existing infrastructure, so it would create longer builds and increase disturbance. And then also substantially it's on unleased BLM minerals, which we are not allowed to be drilling through. We're not allowed to get subsurface easements, so we couldn't use this location, in addition to it being brand new disturbance and pretty remote and rocky. Alternative 3 is in the southwest of the southeast of Section 21. This particular location is outside of high priority habitat and off the unleased BLM minerals. Again, remote and rocky out there. Brand new disturbance, brand new disturbance for access, infrastructure, and pad. This one is off that unleased BLM minerals, but you can see just south of this particular location, we have more unleased BLM minerals that we would have to avoid and then subsequently end up stranding some of that acreage. So we didn't choose this location. Also, the access road and the infrastructure is to the south and would very likely be coming through the high priority habitat. Alternative 4 is in the west half of Section 26, which is on the east half of our unit. This particular location would be brand new pad, access, and pipelines. It's also remote and further from infrastructure, but more also substantially is that the way our unit is, the shape of our unit, operating on this side of the unit, we wouldn't be able to access the southern portion of our unit, the east half of Section 33. So we would potentially need another pad for this location. Also, it's in high priority habitat. Our last option, Alternative 5, is in the north half of Section 33, and it's in another existing oil and gas location that we operate. It's the Peanut Fed 3403. This location would have to be expanded, and it does have existing infrastructure here. However, because of its placement in the unit, we would have to have some additional wells, and also the wells would have to have longer reaches to get to other portions of the unit. And those longer reaches and additional wells create longer timelines that have the potential to increase emissions and truck traffic. Also, this particular location is in sort of the center of high priority habitat, and our understanding is the edge is just a little bit better. So we opted for our Jayhawk Fed location as we found it the least impactful of our options. So zooming into our proposed production facility, this particular location, again, is an expansion of an existing pad, and we'll be able to use an existing access road and gas line. And we're also pretty near existing pipeline infrastructure for oil and water. We will make this pad, we will convert it from its current condition into a tank light pad with line powered production equipment. We will have sound walls on the south and the east side of the pad if we operate within timing limitations. Long-term disturbance here, More than half, about 55% of this pad is outside of high priority habitat. And we do plan to pay compensatory mitigation for both direct and indirect impacts for this location. Other BMPs we plan for this particular location is we plan to have a drill rig powered by natural gas generators, a frac crew powered by natural gas engines. We'll have electrified production equipment. Again, the gas line is in place, but we'll have a produced water line and an oil line in place at the time of production. We'll maintain thresholds for noise and light per Weld County and ECMC regulations. And again, sound walls on the south and east if we operate during high priority habitat timing. We'll be using Group 3 drilling mud, and we did obtain a CPW waiver for chemical storage during frac operations. Additionally, this pad is designed for detention. Per Weld County regulations, we have robust inspection protocols, air monitoring, remote shut-in capabilities, as well as a LAC to transfer the oil directly into the pipeline. This next slide shows some of the proposed benefits of this development. We plan to plug 4 wells on a pad within the unit, and then as part of that we'll reclaim 2 acres of land which is in high priority habitat and remove a number of production equipment, as well as eliminate some truck traffic to that particular location. This slide here on the bottom, it shows, this first line shows the production emissions on the pad that we're going to be plugging and decommissioning, and then this line, the next second line, is the production emissions on the pad that we're going to be reoccupying and modifying. We added those two together and then subtracted it from our proposed emissions on the Jayhawk Fed location for production. And what we ended up with was a net reduction of NOx at 2.61 tons per year of NOx, negative 2.51 tons per year of CO, and negative 6.747 tons per year of VOCs. Running through our permitting timeline, we started this process, as Brett mentioned, in May of 2024 with Weld County, and then we conducted an on-site with CPW in June of 2024, as well as amended our SUA at that time. We submitted our applications in November of 2024, and we received approval from Weld County at hearing in January of 2025. Our OGDP passed completeness in February, and we had a final consultation with CPW in April, and we received our director recommendation also in April. Upon approval of the Jayhawk location, we have a planned, current plans have us starting drilling operations in Q3 of 2025, and then moving on to complete in Q4 of 2025. We should be drilling out and flowing these wells back by Q1 of 2026. And I just want to caveat this is that our schedules are a little bit in flux, so this timing could change. It depends on equipment availability, pipeline construction and constraints, and also our permit inventory, among many other variables. So in summary, this location protects and minimizes adverse impacts to public health, safety, welfare, the environment, and wildlife resources by being sited away from any human receptors and being located partially outside of the high priority habitat. We are using an existing access road, an existing pad, and an existing gas line. Our cumulative impacts will be reduced by connecting to an oil and a produced water line, as well as plugging 4 wells and decommissioning 1 location and modifying our current location that creates a net reduction in VOCs, NOx, and CO for production emissions. That's all I have for you today. We're happy to answer any questions that you may have. Appreciate your time and your review of this application. So thank you.
Thank you very much, Ms. Mitchell. I believe that the rest of the panelists want to visualize. We'll open the panel for questions from commissioners. Commissioners, who would like to have any questions? Commissioner Ackerman?
Thank you, Mr. Chair, and thanks for the presentation. Appreciate you being here today. I have just 2 questions. The first one is just a clarification about the sound walls, and appreciate sound walls being construction on 2 sides if you work during timing limitations. My understanding is those would actually be constructed outside of the timing limitations, not constructed during the timing limitations. Is that correct?
Yes, I think if we intend to operate during the timing steps, we will put them up as we can. They're usually put on ahead of drilling, so we would put them up ahead of that time frame.
Thank you. So they wouldn't be put up during the timing limitations, but would already be existing if you operate within. Thanks. I do have a concern with the timeline as presented. So just wanted to talk about that a little bit. In the materials that I saw beforehand, and understanding that this can be fluid, as you mentioned at the end of your presentation, at the end of your, in the wildlife plan, I think your timing is set forth, and again, it's noted that it can be fluid, but that construction would begin in Q2 of 2025, which of course is already passed, drilling in Q2 of 2025, with completions in Q4 of 2025. And then with some maybe potential spillover into Q1 of 2026 with drill outs and flowback. And then if I heard you correctly, it sounds like the intent is to begin drilling in Q4 of this year with completion, or excuse me, in Q3 of this year with completions in Q4 and then flowback in Q1. Narrowing it to quarters like that is a little bit difficult, as Q1 is essentially the entire extent of the timing restrictions. And so I'm hoping to get, and the reason I'm going down this road, I think you've probably heard me in the past, and I've said this on a number of OGDPs, that when we have high priority habitat, we do have provisions where some work can take place within those timing restrictions, but the intent is to largely avoid those timing restrictions, with the caveat that some might spill over into the timing restrictions as we work diligently to keep things outside the timing restrictions. Can you pinpoint for me a little bit more what you mean by begin, completions in Q4? Because again, Q4 also includes December, which is part of the timing restrictions. As presented, this could, the entirety of completions and flowback could take place during the entirety of the winter timing stipulations, due to the vagueness of the presentation and the details. And so that causes me some concern, and that's not something that I think I'd be willing to approve. So can you put a finer point on what you're looking at there?
Well, I can tell you about what our plan is currently, but again, subject to change. And that would be, we'd start drilling in Q3 of 2025. And I think the way I expressed it to Brandon was that the drilling and completions would take place, all of that prior to the timing limit. But I think the way the schedule has it, again, I cannot stress enough how subject is to change. But it would have us starting the drill outs in December, so we'd be already completed, but then the drill outs would start in December, and it would fall over into about January 6th-ish is what our timing is. We do the quarters. That's how we submit our applications, by quarter. I think it gives a little bit of leeway, but that was our plan according to drill schedules, specifically at the time of application.
Thanks. I appreciate that clarification. I know you've been coordinating with CPW throughout, and especially as your schedule has been pushed back a little bit. I wonder if you'd be amenable to a COA that would lock that in a little bit more. And my proposal would be that those activities would cease by mid-January, giving you an extra week of leeway there. Again, my concern is because you stated that, due to rig availability and things, and I get that we can't control that, but then I have to assume worst case scenario that rig availability, comes available in December. And if we approve something without a COA in there, that it could cruise all the way through, the winter timing stipulations, which is certainly not your intent or our intent. And so
it's not our intent. I think, I guess from our perspective, we are clearly trying to solidify our drill schedule so that we can give a clear schedule to you. It's just not with us right now. And we're also working on increasing our permit inventory to give us options, so that I feel like the more options we have, the more flexible we can be. Obviously, the rules allow for additional compensatory mitigation, so it gives us that operational flexibility. And I think we wanted to conservatively present the fact that it's possible, there's a possibility that we would be within the high priority habitat timing. I think we just want to be practical and straightforward about what abilities we have. It's also possible we can be entirely out. I appreciate the extra week on the COA. I do think that I find it will be hard. I think it could be hard to comply with, just with how many variables there are, how many ways things can be delayed, and how many. I worry about that kind of restriction. I suppose the restriction, but I believe our intention and what I tried to express to Brandon is that we would keep as many phases as we can outside of the timing limitations. We are partially outside of it, so those are my thoughts.
Thank you. I appreciate that response. And again, that response kind of illustrates my concern without a more concrete drilling schedule that it certainly could spill much later, even though our attempts are to do it earlier. And so, that wouldn't allay my concern. I think that I'd certainly be willing to talk about more what ideas you have to present a more concrete drilling schedule or to have some type of a stop date. But I remain a little concerned there. That's the only questions I have, Mr. Chair.
Very good. Other questions for the panel? All right, seeing no further questions, we move to deliberations. Any commissioner desire to give us their thoughts? Commissioner Ackerman?
Thanks, Mr. Chair. Although I think I, largely have made that clear during the questioning phase here, I certainly am willing to kick things off. During the cumulative impacts report out that we had this year, we've talked about how our attempts to protect public, human health and safety have pushed a lot of development away from humans and into wildlife habitat, and we've impacted wildlife habitat increasingly. Now our regs, as Ms. Mitchell pointed out, are set up so that we do allow for some development within high priority habitat timing limitations. But as we impact high priority habitat, it becomes really ever more important that we're careful about adhering to the BMPs that we set up to protect wildlife, and chief among which is those timing limitations, is the avoidance factor. And so the philosophy that I've approached this with from one commissioner's standpoint, again, the wildlife seat, is that the intent of those regulations was to say, okay, we understand that there are a lot of dynamics at play with regard to oil and gas drilling. It's a very complex operation. And 1202D habitats, which these are, can sustain some degree of development with proper BMPs. And the intent of that, as I understand it, was, hey, we can allow some spillover here with careful measures to protect wildlife. The intent was not really to simply weigh the business pros and cons of paying a higher rate for compensatory mitigation, for indirect compensatory mitigation, and I'm not suggesting this operator is suggesting that. But for business convenience to go ahead and push deeper into timing limitations, that was not the intent. And so I have a concern when we come with vague drilling timelines that talk about quarters, and I understand that's what we generally put in our applications, but we generally have a little bit more precision associated with when people are going to get in and get out. And just to be frank, the concern that a COA would cause further limitations on a development really that is not intended to drill deep into high priority habitat really causes me a concern. Now, if everything goes right and we're able to get that done before the timing restrictions, or even a little bit into the timing restrictions, I think that's acceptable within the intent of our regulations. But an approval here today without some kind of assurance that that there is a concrete drilling schedule and completion schedule that wouldn't push right till the end of the timing limitations, it makes me very uncomfortable. That said, as Ms. Mitchell pointed out, this is on the edge of HPH. which is better than the middle of HPH. It's an expansion of an existing location, although a considerable expansion of an expansion. There's an existing access road. There's an existing gas pipeline. There's an intent to be three-phase takeaway, a commitment to be three-phase takeaway. These are all good things. The sound walls during timing limitations are a mitigating factor, as well as produced water pipeline takeaway being a significant mitigating factor for the well-being of wildlife, as well as emissions and other things. As was pointed out, for wells plugged, tank removal, remediation, reclamation of a couple of acres, and a net reduction of emissions, these are all really good things. And so I see this as an approvable application with a little bit more precision and commitment to make sure that the intent of the regulations are being met, that we don't intend to push through the timing limitations, but rather a commitment can be made to be out within the intent, as I see it, of the regulations. Those are my initial thoughts, Mr. Chair.
Thank you for those thoughts. Others with thoughts? Commissioner Messner?
Thank you, Commissioner Ackerman, for your thoughts on that. Always appreciate your expertise associated with wildlife and how the wildlife regulations get applied in our review processes. In the conversations that I've had with CPW regarding timing stipulations and activities that may bleed into those timing stipulations, one of the things that was continually emphasized to me from multiple CPW representatives was that operations that start outside of a timing stipulation, but then bleed into a timing stipulation to some point, are far more preferred than those operations that begin within the timing stipulations. And I think that's why Commissioner Ackerman's emphasizing the certainty that needs to happen, that some operations would start outside of the timing stipulations and then move into the timing stipulations to some degree, because then the species have the opportunity to make a decision of whether or not they would occupy those particular areas or not, based on the level of activity that they're seeing in those areas, versus having those species already be in those high priority habitats and then being directly impacted by new operations in an area where they've already chosen to habitate. And so I share Commissioner Ackerman's concerns associated with the lack of commitment to beginning operations outside of the timing stipulations and move into those timing stipulations with some sort of bleed that would require compensatory mitigation versus the timeline as proposed in the application that creates enough flexibility for operations to actually begin in those timing stipulations and continue clear through the timing stipulations. Those are real concerns, I think, associated with us being able to properly apply the rules and the act. There are so many things about this application that are excellent, and I do want to emphasize that. But this is a sticky point. We're required to apply the rules in the act, and those applications that don't properly meet those rules in the act can't be approved. And so I think Commissioner Ackerman I think what I'm hearing you ask for is a condition of approval or some mechanism from the operator that would apply certain best management practices that I assume CPW also understood to be the case, that activities would start outside of a timing stipulation and bleed into it versus activities that would start inside of that timing stipulation and continue through it. So I'm not sure. That's my initial thoughts on that. I'm not sure where I would go with this, but I would have to agree with Commissioner Ackerman on this one.
Thank you for the thoughts. Others with thoughts? Commissioner Oath?
Thanks. Honestly, I don't really have much to add. I would just chime in and indicate that I am in agreement and appreciate kind of both of you sort of explaining um, how those regulations came to be and the intention for applying them and the reasons behind that certainly makes sense to me. So I'm in alignment as well.
Commissioner Ackerman, would you like to make a motion?
I sure will. And just to be a little more clear for those that are listening in and also for Verdad, again, I agree, lots of good things about this application. I think that really what's causing me concern is the lack of precision associated with commitment on that timeline. We've had other applications that have come for us before that are very similar, that have said very similar things, but then the actual schedule is set forth, and this is our actual proposed schedule down to the month. And we've approved those applications moving forward with some degree of assurance that this is, our schedule. And even though there's some flexibility in those schedules, there's a difference between flexibility in a schedule that says we will be done completing wells by December 15th, give or take a few days, than one that only kind of drills down to quarters. And so that's why this is a nuanced concern for me, and I wanted to make sure and clarify that. I would set forth a proposal that we entertain a motion that approves this application with a condition of approval that all pre-production activities would be complete by January 15th. That'd be my motion, Mr. Chair.
Thank you for the motion. Do we have a second?
Second.
Further discussion on the motion? Seeing no further discussion, all those in favor of the motion signify by saying aye.
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 Aye. Any opposed? That motion carries. All right. Thank you, Mr. Obrick, for the presentation, and Ms. Mitchell. We conclude the hearing on that application. Looking at our agenda, I see nothing further. I move to adjourn.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? We are adjourned. We will see you next week. Thanks.